Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 misconceptions people have about copyright law. Copyright law is federal law, so it's only appropriate that I'm here at the federal U.S. courthouse in downtown Austin. So if you hear a little traffic, that's behind me over there. So anyway, I did a Top 5 Tuesday previously about misconceptions people have about intellectual property law, but I thought maybe that was too general, and so I should dig a little deeper and talk about some specific areas of intellectual property law. So this is copyright law, and the number 5 misconception about copyright law is that copyright protects single words or short phrases or logos or that sort of thing. So, for example, that Disney might have a copyright to the phrase Mickey Mouse. Well, that is really the realm of trademark law, not copyright law. Copyright is going to cover works that are a little longer, movies, novels, songs, recordings, things of that nature. And you could have something very short. For example, a haiku could be subject to copyright protection. But something shorter than that, one word or a short phrase, that's more likely to be covered by trademark law, which is an entirely different animal. Number 4 is that people think you have to register a copyright to have any legal rights in enforcing it. That's not exactly right. Copyright is actually created at the moment that somebody creates an original work of expression. So for example, if you're writing a novel, the moment you put pen to paper and you write the words of that novel, that is subject to copyright protection. Now, there are certain legal benefits that you get from registering your copyright with the U.S. Copyright Office, and those can be significant, but that registration itself is not what creates your copyright. The number 3 misconception people have about copyright law is that they think that the person's wrongful intent is what creates liability for copyright infringement. So for example, if I deliberately copy somebody's song and then I have a hit record with it and I was intending to steal that song from them, that's what's important to copyright infringement. That's not exactly right. In most cases, the big fight in a copyright infringement lawsuit is going to be whether the two works are substantially similar, and not so much over whether somebody did something wrong. Now, the intent of the defendant can come into play when you're talking about the issue of actual copying and whether that actually occurred. But that's usually more a question of whether the defendant had access to the original work and how similar the original work is to the new work. So intent is not really the crucial issue. The number 2 misconception people have about copyright law is kind of related to number 3. It's the idea that you can avoid liability for copyright infringement with some kind of disclaimer that shows you didn't intend to violate anyone's copyright. You see this, for example, on YouTube, where people will share copyrighted material and they'll put some kind of disclaimer that says, I don't own this recording, I don't claim any copyright to it. I'm not sure exactly how that got started and what the thought was behind that, but a disclaimer like that is not really going to make much difference to whether there was copyright infringement. Now, maybe it might come into the question of fair use, which is a defense to copyright infringement that is kind of vaguely defined by the law. But generally speaking, you can't avoid liability for infringement just by putting a disclaimer that says, I don't own this copyrighted work. Okay, finally, the number one misconception about copyright law is thinking that copyright law protects people's original ideas. That's not true. If you talk to any copyright lawyer, pretty quickly you're going to hear them say something like this: copyright protects the expression of ideas, it does not protect the ideas themselves. Now that's pretty abstract, and that can be a little bit difficult to apply in practice. But let me give you an example. Let's say I have an idea for a TV series, and the idea is that there's a high school chemistry teacher who is diagnosed with cancer, and he's going to die in a year, and he decides that what he's going to do to make money for his family is he's going to become a crystal meth dealer. Okay, so most of you are thinking, that sounds like Breaking Bad. That's already been done. Somebody had that idea. You can't do that. Well, actually, I mean, maybe you shouldn't do that because it would be a pretty blatant ripoff of another show's premise, but it's not a ripoff that would necessarily violate copyright law because you're allowed to copy that idea. What you can't do is copy the expression of that idea. So you couldn't take a script from one of the Breaking Bad shows and copy that script and, you know, maybe make a few minor changes and then try to pass that off as your original show. That would be substantially similar to the copyrighted script, and that would be copyright infringement. Okay, so those are the top 5 misconceptions about copyright law. Thanks for watching.